19 years old, 18 prior convictions. That's not a typo. That's the record sitting on this judge's desk right now in a courtroom in Warren County, Ohio. And in the next 12 minutes, you're going to watch exactly what happens when a system that's been giving second chances for 6 years finally runs out of them. Stick around, because by the end of this, you'll understand why the judge stopped mid-sentencing just to count out loud. His name is Darren Oldham, Warren County, Ohio. By the time most kids are worrying about driver's ed, Darren was already a regular in the juvenile court system. His file goes back years, and it's long, breaking and entering not once, 3 separate times, grand theft, twice, stealing a car, carrying a concealed weapon as a minor, burglary, receiving stolen property as a felony charge more than once, and running from police, what the courts call failure to comply, at least twice before he was even old enough to vote. 18 separate cases. 18 times a judge in that county looked at this kid and decided, not prison, not yet, give him another shot. Then he turned 18, and almost immediately he was back, this time as an adult, facing 2 brand new felony cases, one for fleeing from police again, one tied to a firearm. His attorney, a man named Brenner, who'd actually represented Darren years earlier as a juvenile, stood up first, and he didn't try to hide the record. He called it what it was. Bad, but he made his case anyway. Darren was 4 credits away from finishing high school. He'd told his lawyer he wanted to be a businessman someday. He'd already spent 92 days in jail waiting for this hearing, by far the longest he'd ever been locked up. And according to his attorney, that alone had been a wake-up call. There was more. His mother's husband was in the Air Force, and the family was relocating to Colorado. The defense argued that getting Darren out of Ohio, away from the same environment that kept pulling him back in, might be exactly what finally broke the cycle. The ask was simple: no more prison, just probation, one more time, with the long suspended sentence hanging over his head as motivation. Then it was Darren's turn to speak. He kept it short. He told the judge he was good at taking accountability, that he understood what he'd done wrong, and that it wouldn't happen again. The judge asked him something simple first. How many times have you stood in front of a judge and said exactly that? Darren said never. The judge didn't believe him, and instead of just saying so, he opened the file and started counting out loud, one by one, in front of the entire courtroom. 1, 2, 3, all the way up to 18. Felony receiving stolen property, multiple obstructions, 3 separate breaking and enterings, a concealed weapon, 2 counts of grand theft, a stolen vehicle, a burglary, 2 prior failure to comply charges, meaning this wasn't even his first time running from police. And every single time, the same result: a suspended sentence, another chance, another suspended sentence again. Here's what makes this county different, and it's worth knowing before the sentence comes down. A few years back, a sheriff's deputy in this same jurisdiction was killed after a suspect fled from police and struck him. That's not background noise. That's the reason this judge, in this specific courtroom, treats fleeing from officers as close to a zero-tolerance offense. So when the judge looked at Darren's file and saw not one, but multiple counts of running from police, that history was sitting right behind every word he said next. The judge made his ruling clear before reading out numbers. This wasn't a case for community control. Given the extent of the record, probation would not seriously punish the offense, and prison was necessary. Here's what Darren actually got. On the first case, the failure to comply charge, 12 months in prison. On the felony receiving stolen property charge tied to that same case, another 12 months. And by law, those 2 had to run back to back, not at the same time, one after the other, 2 years total just on that case alone. On the second case, the one tied to the firearm, another 12 months in prison, plus a 6-month county jail sentence running alongside it. On top of all of that, his driver's license was suspended for life. The gun was ordered forfeited. He was given credit for the 92 days he'd already served, and once he's finally released, he's subject to up to 2 more years of supervision, where a single violation could send him straight back. But the judge didn't stop there, and this is the part most people miss. Before sending Darren off, he made a point of speaking to him directly, one more time, not through the lawyers, not through the file. To him, he said essentially that nothing the system had done for Darren up to this point had actually worked, and that he wanted to try something different. He told Darren he'd consider a motion for early release after 6 months, with a condition attached: no gang involvement, no rule breaking inside the institution, follow the rules, and there's a real path back to community control instead of serving the full sentence. One condition, one warning. Break it, and that door closes for good. So here's where this leaves things. 18 chances didn't change anything. Whether a 19th, with a hard deadline and a real consequence attached, does anything different? Nobody in that courtroom knows yet, not even the judge. What do you think? Did this system wait too long to draw the line? Or is 6 more months in prison, followed by 1 more shot at freedom, actually the right call? Tell me in the comments. And if you want to see how these judicial release cases usually turn out, that's exactly what we're covering next.